Academic and Student Affairs of Law Faculty of Universitas Hasanuddin, Professor Dr. Maskun Esa LLM. The Honorable guest speaker of today's guest lecture, Professor Emily Crawford, BA, LLB, PhD. The Honorable, the lecturers of Law Faculty of Universitas Hasanuddin, and also all of the participants who have attended today's guest lecture. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh.
Shalom, Om Swastiastu, Namo Buddhaya, and good afternoon to all of us. Welcome to the guest lecture with the theme of Non-Binding Norms in the Law of Armed Conflict conducted by Faculty of Law Universitas Hasanuddin. I'm Nanda Yuniza, will be serving you today as your Master of Ceremony. First of all, let us offer praise and gratitude for the presence of God. Because of His mercy and blessing, we can gather today in here to attend this guest lecture. Therefore, let us open today's guest lecture by reciting Basmalah. Bismillahirrahmanirrahim. Let's move to our first agenda. Opening remarks by the Vice Dean of Academics and Student Affairs of Faculty of Law Universitas Hasanuddin, and also to officially open today's guest lecture to Professor Dr. Maskun Esa LLM. Time is yours.
Thank you, Nanda. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And then good afternoon, everybody. The Honorable Professor Emily Crawford, BA, LLB, and then PhD, and also the Honorable for all these lectures from Faculty of Law Hasanuddin University, and then all the participants who attend the guest lectures today. And also, I would like also special thanks also to Alif, that's the former student in our faculty actually, and right now I carry on his study in Sydney Uni. Thank you for helping us to create this guest lecture. It is my distinct honor and then privilege to welcome our distinguished speaker to this esteemed webinar to this afternoon. This is a momentous occasion, and we are truly fortunate to have someone of such stature and expertise here with us. Of course, our distinguished speaker's name is synonymous with excellent and accomplished in her field. Professor Crawford teaches international law, international maritime law, and then international criminal law. Today, we have the privilege of hearing from a visionary and then a true inspiration to us, to all of us. And then I encourage each of us to open our hearts and mind to the profound insight that will be shared by Professor Emily. And then it is through this moment that we can gain new perspective, find inspiration, and then of course foster personal and then collective growth. Our distinguished speakers presence here today underscores the importance of the idea and then discussion that will unfold. We are here to learn, to engage, and then to be inspired by their wealth of knowledge and then experience. So without further ado, please join me in giving our warmest welcome to Professor Emily in this guest lecture in Faculty of Law Hasanuddin University. And then on behalf of our Dean, Professor Dr. Hamzah Halim, Esa, MH, MAP, because in the same time he has another meeting that's all important for us, so that's why I have to be a representation person to give the speech this afternoon. As you know, Prof. Emily, I would like to report also to you that the guest lecture today we create in the hybrid, and then in this what we call in our faculty in moot court room, there are around 80 students. There are 80 students who attend this guest lecture. So it means that almost 100 participants is coming for all levels, postgrad, undergraduate, and then postgrad student from Faculty of Law who attend your lecture this afternoon. So, and then let me ask together to say Bismillah, and then the guest lecture today we open officially. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Yes. Thank you, Professor Dr. Maskun Esa LLM, for your remarks and willingness to open the guest lecture under the theme of non-binding norms in the law of armed conflict. The opening remarks from the Vice Dean of Academic and Student Affairs of Faculty of Law Universitas Hasanuddin also become a sign of the end of the opening ceremony. Here we are going to the main agenda of today's event, which is material presentation of the guest lecture by the distinguished speaker, Professor Emily Crawford, BA, LLB, PhD from University of Sydney Law School. This agenda will be led by Mrs. Mutia Wendah Junior, SH LLM, as the moderator. Without any further ado, we would like to call Mrs. Mutia to moderate the session. Time is yours, Miss.
Okay, Assalamualaikum warahmatullahi wabarakatuh, and good afternoon, everyone, and good afternoon or good evening, Professor Emily in Sydney. My name is Mutia Wenda Junior, and I will be your moderator for today. And before we proceed to the lectures, let me introduce Professor Emily background. Prof. Emily is the Program Director of International Law in the University of Sydney Law School. Professor Emily also teach and research in international law, international humanitarian law, and international criminal law. Prof. Emily has published widely in the field of international humanitarian law, including 3 monographs. First is the treatment of the combatants and the insurgents under the law of armed conflict in 2010. And the second is identifying the enemy, civilian participations in hostilities, 2015. And the last is the non-binding norms in international humanitarian law, efficacy, legitimacy, and legality in 2021. So now, please welcome Prof. Emily Crawford. Time is yours.
Thank you. So the last 30 years has been witness to a proliferation of non-binding instruments or soft law instruments in the field of the law of armed conflict, which is also known as international humanitarian law, or IHL. During the heyday, if you will, of these instruments between around 2004 and 2020, around 15 different documents were produced that aimed to guide state and non-state practice in a variety of different areas, including things like cyber war, air and missile warfare, the use of private military and security contractors, and peacekeeping operations. And for a period of time, it really looked like non-binding instruments were becoming the standard for creating new norms in the law of armed conflict. However, in the last few years, notable attempts at creating or updating non-binding instruments seem to have stalled, and in some cases fallen apart completely. Drawing on research previously published in my book on non-binding norms in international humanitarian law, I wanted to talk a little bit about soft law instruments in the law of armed conflict, their proliferation, and whether there is genuinely a seeming turnaround in the fortunes of non-binding instruments. Essentially, have soft law non-binding instruments had their day in IHL? So as I mentioned, over a period of about 30 years, something like 15 soft law instruments have been produced or adopted. Now, 15 in 30 years doesn't sound like much. It's really only one every 2 years. However, it's worthwhile knowing a little about how these instruments came about to understand why this proliferation can indeed be seen as a proliferation. But before I get into that, let me set the scene a little. First, it helps to set the parameters of what is meant by soft law. It's a contested area, There are numerous scholars who virulently oppose the very idea of even entertaining a category of soft law, arguing not unfairly that law is meant to be determinate and to set up binding rules that come with sanction for non-compliance. So to have a category of rules that have no sanction attached to their non-adherence just makes it ethics, not law. I spend some time in my book going over these arguments, and I won't repeat them here. They are all very essentially just surveying the literature. For our purposes today, and honestly for my book more generally, I take the position that regardless of one's position on them, soft law instruments exist, and they are treated with some degree of meaningful consideration that warrants their examination. So we can consider soft law instruments as Christine Chinkin has defined them: any instrument or provision that meets any of the four possible determinants, that it has been articulated in non-binding form according to traditional modes of lawmaking, that it emanates from bodies lacking international lawmaking authority, that it is directed at or designed to include non-state actors whose practice cannot constitute customary international law, or it is predicated on voluntary adherence or relies upon non-juridical means of enforcement. So with this in mind, it is useful to do some additional scene setting in relation to soft law instruments in IHL. The law of armed conflict is one of the most regulated fields of international law. Since the first treaty regarding conduct in armed conflict was adopted in 1864, dozens of treaties have been adopted regulating the treatment of, among other things, civilian populations, prisoners of war, specific means and methods of warfare, and the protection of cultural property. This proliferation of binding documents has been supplemented by comprehensive customary international law relating to armed conflicts, as well as related treaties on the protection of children, the protection of refugees, and on international criminal law. So despite there being literally thousands of provisions governing the law of armed conflict, the law of armed conflict has always been subject to one very particular apposite criticism, namely that there has been a historical inability to effectively predict new developments and to proactively develop laws to deal with them. So there seems not to be this ability on behalf of states to recognise changes in the landscape and to then adopt new laws before those changes really start to come into effect. And there is some truth to this. IHL treaties have, for the most part, been reactive, responding to the conduct of the most recent conflict, rather than predicting conduct yet to come. Now, I would argue that most law, both domestic and international, is somewhat reactive, but that's a discussion for another time. In any event, IHL gets tarred with the adage that it is fighting the last war, or that it is one war behind reality. And to some degree, this is true. If you want to understand the reason why a particular provision of IHL exists, you just look to the war that had been fought just before its adoption, and you'll get a good idea of why the law is the way it is. Coupled with the retrospective quality of many IHL treaties, it has been a seeming paralysis on behalf of the international community to better regulate armed conflict in light of new developments in practice, where the 1940s, 1950s, 1960s, and 1970s saw the adoption of several groundbreaking treaties like the Geneva Conventions and the additional protocols. By the 1980s, these big picture lawmaking endeavours were quickly replaced by far fewer and far more modest treaties, largely devoted to regulating types of weapons. And by the late 1980s, early 1990s, treaty making in IHL seemed to grind to a halt, even as the international law community embraced a new era of lawmaking as the Cold War divisions, at least temporarily, seemed to abate. So despite there being ample areas where the law needed updating, there seemed little political will to do so. So into this breach of lawmaking, soft lawmaking or informal lawmaking seemed to offer an ideal solution, a way in which interested stakeholders could debate and draft guiding instruments on the most pressing issues of international humanitarian law, without having to engage with the politically charged and potentially slow lawmaking processes of the UN or of state-based treaty negotiations, or through the slow development of customary international law. Soft law seemed an ideal solution for a timely response to important issues. So by the late 1980s, soft law started to emerge as a possible solution to regulatory impasses. And it was around this time that a small group of academics and practitioners in the field of naval warfare began to ponder whether some of the rules on naval warfare might need updating in the form of a soft law instrument, in some respects, driven by some of the naval engagements that had taken place during the Falklands War of 1982. And I'm going to focus on this particular instrument, the San Remo Manual, because it really illustrates some of the strengths of soft law in international humanitarian law. It demonstrates some of the processes which have been common to soft law instrument adoption, but it also essentially is both the beginning and the end in one, which we will see as I get to the end of my presentation. So to give some background on the creation of the San Remo Manual, in 1986, 4 years after the end of the Falklands War, the 25th International Conference of the Red Cross adopted a resolution stating that the law on naval warfare was indeed in need of reaffirmation and development, considering that the treaty law on the conduct of hostilities at sea was both fragmentary and old, mostly dating back to the 1907 Hague Conventions, and supplemented only by two non-binding instruments from 1909 and 1913. So written law had not been updated to reflect major technological and scientific developments in the conduct of naval warfare over a period of nearly 80 years. Additionally, in that period of time, there had been the adoption of major treaties on the law of the sea, not least of which being the United Nations Convention on the Law of the Sea, which impacted how naval warfare was being conducted in the latter part of the 20th century. So with that background in mind, a group of experts convened in 1987 and devised a plan of action for regular meetings in which a contemporary restatement of the law of armed conflict at sea in the form of a manual should be adopted. And the subsequent meetings culminated in the adoption in 1994 of the San Remo Manual on International Law applicable to armed conflicts at sea. And it's worthwhile going a little into the process that led to the adoption of the San Remo Manual, and that's for two reasons. One was it was the first of this kind of modern era of non-binding instrument, and its success set the stage for other manuals to follow, in particular in terms of how they were drafted. And second, a notable number of the experts involved in the San Remo process ended up either participating in or initiating other soft law processes in IHL in the years that followed. So for better or worse, San Remo set the standard that was followed for the next 30 years. So 1987, the International Institute of Humanitarian Law, based in San Remo, in conjunction with the universities of Pisa and Syracuse, convened a round table of experts in San Remo to review the law and draft a plan of action. With the support of the ICRC, roundtables were held annually in Madrid, Bochum, Toulon, Bergen, Ottawa, Geneva, and Livorno. The standard practice was for a report by an expert rapporteur to be circulated amongst the experts for comment, and the comments were in turn disseminated amongst the participants. At the roundtable itself, individual topics and issues covered by the rapporteur were assigned to working sessions, where a discussion leader facilitated and structured the discussion on the issue in plenary. Then following the plenary discussion, the discussion leader produced an initial draft of the conclusions of the working session, And then towards the end of the roundtable, all discussion leaders, in conjunction with the rapporteur and the editor, met to draft the overall conclusions of that roundtable. The results of that final drafting group meeting were then submitted to the roundtable at the final session, with agreed alterations upon being made. This process was followed at all subsequent roundtables, although with different rapporteurs dealing with different subjects. After the fourth roundtable at Ottawa in 1992, a harmonisation committee was convened with the aim of harmonising the terminology used in the varying documents adopted at the end of each roundtable, and then deciding on a logical order of paragraphs and reviewing the commentary that was written by the rapporteurs. The committee met again following the fifth roundtable to finalise the harmonised text of the manual and the explanation, which essentially served as a commentary. And then the final roundtable, held in Livorno in 1994, reviewed and approved the final text and accepted but did not formally approve the explanation. Now, the experts involved in the debating and the drafting of the San Remo Naval Manual can be broadly categorised into two groups. There were the participants, who were involved in the drafting process as well as the roundtable discussions, and the associated experts and observers. They attended the meetings but were not involved in the drafting process. So of the 56 participants, there were the rapporteurs, the authors of the special reports, the authors of the background papers, the members of the harmonisation groups, and the authors of the explanation, as well as other experts drawn from academia, from the armed forces, from civil society, and from government. In all, 22 of the participants were from academia, 29 were from government and the armed forces, and 5 were from civil society organisations like the International Committee of the Red Cross. So those were the participants. The participants were then joined by 94 experts and observers who attended meetings but did not draft any of the relevant documents. All participants, experts, and observers participated in the process in their personal capacity and not as official representatives of their states or of their institutions. The majority of the participants and observers were drawn from the Western European and Others group, the WEOG group of states. So of the 94 experts and observers, 64 were drawn from the WEOG states, so from Western Europe, the United States, Canada, Australia, New Zealand. 44 of the 56 participants hailed from WEOG states. The Asia Pacific group accounted for the next largest group of participants, 20 in total. There were 10 from the Eastern European group, 9 from the Latin American and Caribbean group, and 4 from the African group. So as you can see, it was a very heavily Western European process. Now, while the number of participants, experts, and observers totaled 150, not all of them were involved in all stages of the San Remo process. The Madrid Plan of Action had intended for the work to be undertaken by only about 20 experts, with some attention paid to geographical representation. Ultimately, each meeting was attended by about 40 people, with around 25 experts personally attending all or most of the meetings. Therefore, of the 150 involved in the process, only a small percentage was part of the core group of experts who oversaw the final instrument. Now, the manual attributed this difference in numbers to several factors. First, some specialist experts were invited to only some of the meetings in order to contribute their expertise on particular key issues. Some interested observers attended only some of the meetings. Some persons attended by virtue of their function. For example, the senior judge advocates of certain navies. But the individuals, of course, changed from time to time when people stepped out of particular positions. And then finally, some individuals attended only the first 1 or 2 meetings or only the last 1 or 2 meetings. So as you can see, there was a varied number of participants, but only a very small core group. And at all stages, there was a very high emphasis on experts being drawn from the Western European and other collection of states. So to turn to the document itself, the manual as adopted comprises 183 rules, accompanied by an explanation, essentially a commentary to the rules written by the rapporteurs for the round tables. The stated intent of the manual is to provide guidance for practitioners in the field of naval warfare. For the most part, the manual positions itself as lex lata, as a statement of the law as it exists today. Any innovation or progressive development in the law is largely attributable to having to examine practical developments in the related fields of international law, such as the law on the use of force and the law of the sea. Because neither the UN Charter nor the UN Convention on the Law of the Sea had been in existence at the time of the adoption of the extant treaty law on naval warfare. So the developments in these areas, namely the prohibition on the use of force and peacetime legal regimes relating to certain parts of the sea, needed to be acknowledged where they impacted on the law of naval warfare. Other developments, such as changes in the law and technology relating to aircraft, were also noted. And additionally, developments in the general law of armed conflict, namely the adoption of the additional Protocol 1 concept of military objective, also influenced the manual, in that the concept of a military objective, as understood in Additional Protocol 1, did not exist in the traditional law of naval warfare, but was included in the final manual. So it was a long process to draft the manual. There were certain very specific representation issues, and it eventually came out with a very long, detailed document, but that was for the most part attempting to state the law as it existed at the time. The document was then released, and it was open to states to use it if they wished or ignore it if they wished. It wasn't a treaty. There were no binding obligations on states to respect any of the findings found by the San Remo process. But within 10 years of the adoption of the San Remo manual, it was clear that it was being widely accepted as being declaratory of the present law of naval warfare. The manual was noted approvingly in numerous military manuals in several states, and particularly specially affected states, those states that routinely engaged in naval military operations. Academic and practitioner assessment of the manual was likewise very positive. The International Committee of the Red Cross, when undertaking its study into the customary status of international humanitarian law nearly 20 years later, decided not to examine the law of naval warfare. As they said, this area of law was recently the subject of a major restatement, namely the San Remo Manual on Naval Warfare. Likewise, in practice, we see the manual being affirmed. Israel, in response to the 2010 Mavi Marmara incident, justified its conduct by invoking the San Remo Manual. The inquiries made into the incident by both Israel and by a UN panel of inquiry also repeatedly made reference to the manual as being a relevant source of law. More recently, the ICRC, in its updated commentary on the Second Geneva Convention regarding the wounded, sick, and shipwrecked members of armed forces at sea, noted that the San Remo Manual is, for the most part, still a valid restatement of the customary and treaty international law applicable to armed conflicts at sea. As Stephen Haynes points out, there is strong evidence that the San Remo Manual is widely regarded as a reliable statement of the law of armed conflict to be applied at sea during times of armed conflict. It's safe to say that the success of San Remo emboldened a whole field of informal international lawmakers in the law of armed conflict. In the years that followed San Remo, the field welcomed, or as you'll see in a minute, in some cases didn't, a variety of documents, including the San Remo Manual on the Law of Non-International Armed Conflict, the Montreux document on pertinent international legal obligations and good practices for states related to operations of private military and security companies during armed conflict, the Manual on the International Law applicable to air and missile warfare, the Copenhagen Process Principles and Guidelines on the handling of detainees in international military operations, the Tallinn Manual 1.0 on the international law applicable to cyber warfare, and the Tallinn Manual 2.0 on the international law applicable to cyber operations, the International Committee of the Red Cross's study into customary international humanitarian law, the ICRC interpretive guidance on the notion of direct participation in hostilities under international humanitarian law, the Leuven Manual on the international law applicable to peace operations, the Oslo Manual on select topics of the law of armed conflict, the International Code of Conduct for Private Security Service Providers, the McGill Manual on international law applicable to military uses of outer space, and the 5 deeds of commitment produced by the non-governmental organization Geneva Call, designed to guide the behavior of non-state armed groups in relation to things like the protection of healthcare, the use of landmines, and the non-use of children in armed conflict. Now, also being debated at this time, though not yet at the stage of publication, it includes the Woomera Manual on the International Law of Military Space Operations, an updated San Remo Manual on Naval Warfare, an updated Tallinn Manual 3.0 on cyber operations, and now the recently published Newport Manual on the law of naval warfare. Now that's quite a list. By contrast, over this same period of time, the international community adopted only a comparatively small handful of significant, but still very narrowly focused treaties, primarily on weapons control. So we've seen adopted in this time treaties on nuclear weapons, landmines, cluster munitions, and binding laser weapons. So a very small number of binding treaties in comparison to a fairly high number of non-binding instruments. So there's been no shortage of instruments on varied and complex issues in the past 30 years. The question I wanted to find an answer to, if possible, was, did any of these non-binding instruments actually have an impact? Because at the core of questions about non-binding instruments is, why adopt them? If there's no binding force, if there is no sanction for their non-compliance, why adopt them? Do they actually have any impact in shaping state behaviour? Did any of these manuals, which essentially aimed in their own cases to be the definitive statement on the law as it exists in relation to any particular area, did they get used in practice as being the definitive statement? The short answer has been mixed, essentially. The San Remo Manual on Naval Warfare was immensely successful and widely embraced in practice. Likewise, though not without some controversy, the ICRC's customary law study is now generally considered the authoritative instrument of customary international humanitarian law. However, most of the other instruments have found surprisingly little traction in state practice. Very few have been cited before international bodies such as the United Nations or the ICJ, and only a very small handful have found reference in official documents of states or in domestic court cases or domestic military manuals. Now, all of this needs to be assessed with a degree of circumspection. When I did my study into this, I was working off only what was publicly available in terms of things like publicly published court transcripts, documents from international and national bodies, as well as what I could translate from my own rudimentary French, German, and Spanish. It is entirely possible that there are troves of confidential or classified government documents where provisions of particular manuals, such as the Air and Missile Warfare Manual, are repeated and followed verbatim. But I have to say, I don't think they are. So my research has found that that only a very small handful of these documents have gained any traction in state practice. I will give some reasons as to why I think they might be the ones that have gained traction. Adding to this complex mix is an additional ingredient. Those recent instruments I mentioned, the Woomera Manual, the San Remo Naval Manual Update, both of these seem to have hit impasses. Having been tracking their development, I have not been able to find information about whether or when the Woomera Manual is going to be published, or whether the update of the San Remo Naval Manual is going ahead. Now, part of this can be attributed to the schism created by the COVID pandemic, which has disrupted drafting and publication processes around the world. But I suspect that there may be other forces at play. And I say this as someone who had been involved in soft law processes during this time. San Remo set the stage for a coherent, well-received and well-supported instrument, which seemed to portend a healthy template for informal international lawmaking going forward. However, there were key elements that San Remo possessed that many of these less successful instruments did not have. First, San Remo was adopted at a time of unprecedented interstate collaboration and optimism. For those among us here today old enough to remember, we can recall the heady days in the wake of the end of the Cold War, when raconteurs boldly pronounced the end of history and that the deadlock of the Security Council was a thing of the past. So San Remo benefited in large part from this spirit of collaboration and optimism that seemed to be a hallmark of a very short period of time between about 1989 and 1995, 1996. At the same time, San Remo also benefited from practices that would not stand scrutiny today. As I mentioned, the vast bulk of participants in the San Remo process were drawn from Western Europe, the US, Australia, Canada. There was nominal representation from Africa, from Asia, and from South America. And for an instrument that claims to speak about a universal international law, this limited geographical representation of participants and experts would not stand up to scrutiny, would not help any claims to universality today. On a more quotidian level, San Remo was very well funded. States really bought into the process, and the institutions that supported the process also made sure there was sufficient funding. From my own experience in a soft law instrument, my participation was largely self-funded. Getting funding for the workshops and the roundtables for our soft law instrument was always a pressing concern, so that the general editors, rather than spending their time worrying about how to actually draft the instrument, they were spending their time worrying about how they were going to get funding. And on top of that, nearly all participants in the process were doing this work in addition to their full-time jobs. We were taking time off from our full-time teaching and research in order to contribute to this process. And again, this placed considerable strictures on how frequently we could meet and how much could get done at each meeting. Geographical restrictions were also a considerable limitation. Those of us keen to provide our expertise were always going to have the tyranny of distance and finance and time as a potential roadblock to shepherding those instruments to completion. From my own experience, again, we found it immensely hard to find dates that we could bring the majority of the experts together, because at times where, say, people in the Southern Hemisphere were not teaching because it was their summer break, it was a peak teaching time for people in the Northern Hemisphere, or vice versa. And so it meant times that were suitable for meetings in the Northern Hemisphere did not work for people in the Southern Hemisphere. So my research in looking at all of these documents has shown that a complex number of factors need to come together in order to make these instruments work. And that while soft law instruments seem very appealing because they seemed to circumvent the kinds of strictures that come from treaty making, that you don't actually have to have agreement among multiple numbers of states. You don't need to have 180 states agreeing on something. Instead, you could just have 25 experts get together. While obviously the soft law instruments seem to offer this promise of avoiding the kinds of legislative bottlenecks, if you will, that happen in venues such as the UN, there were many other strictures that prevented these documents from becoming everything they could be. And that even the ones that were well-funded, well-attended, had good geographic representation, that did not seek to push the law further than it needed to be, they still haven't gained the kind of traction that their drafters seemed to hope that they would. So where does this leave non-binding instruments now? Clearly, they are still being drafted. Recently, there have been attempts at putting together a guiding document on the process of weapons review, as provided for in Article 36 of the additional protocol to the Geneva Conventions. And I myself am currently working on a code of conduct with regard to state nuclear command, control, and communication structures. So clearly, this is not the end. Soft law has had a long role to play in IHL. Arguably, modern international humanitarian law as we know it would not exist if it weren't for a soft law document, Henri Dunant's 1863 pamphlet, A Memory of Solferino, which ultimately led to the creation of the International Committee of the Red Cross. But it might be time for a more balanced approach. Perhaps in addition to devising new ways to guide and regulate behaviour in armed conflict, it might be useful to explore why certain treaties have succeeded recently where other attempts have not, to balance the non-binding with the binding. The recent success of the long-delayed Nuclear Weapons Prohibition Treaty demonstrates that success can come from the involvement of civil society, with states to position to better push for particular outcomes. And I think also at the core of this, there's a need to explore why is it that states have been unwilling or unable to make the kind of big leaps of judgment or the big leaps of faith behind the adoption of big treaties like the Geneva Conventions, the additional protocols. Why in the realm of armed conflict, where there is widespread agreement that the documents, though well respected, are increasingly out of date and increasingly don't reflect the environment in which armed conflicts are currently being conducted, we might have to look at what it is about the political situation that is maybe preventing this kind of bold international lawmaking that really was the hallmark of the immediate post-World War II era. So I'm going to wrap up the formal part of my presentation there because I would like to turn now to your questions and for us to have a bit of a discussion about this, because this is not a concern just for international humanitarian law. Non-binding instruments are a common feature of a number of different areas of international law. They are a hallmark of international human rights lawmaking, of international environmental law, and international economic law. And they have been very, very successful in those fields of international law, but they're not so successful in IHL. And I think that we need to look at the reasons why states seem to be, in some respect, abdicating their role as lawmakers in treaty form, when for so long they've been the primary drivers. So I'd like to now hand back to our moderator, and I'm happy to take any questions that you might have.
Thank you so much, Prof. Emily, for the insightful lectures. Now we can proceed to the question and answer sessions. So if there's anything to ask to Prof. Emily, please raise your hands in Hartum or whether in the Zoom, you may raise hand and don't forget to mention your name. Okay, please, anyone? Okay. So I see there are two who raise their hands in Zoom. So first, Pak Riyad Anwar, you may ask Prof. Emily.
Hi, am I audible?
Yes.
Okay. First of all, apologies if there is a noise in here because I'm outside, but I'll try my best. So thank you very much, Professor Emily. This is really extensive presentation of how the process of the manual and non-binding instrument was being formed and how it's slowly developed into something that we become implementable, not necessarily as legal instrument, but as, like you say, for example, a best practice in here. Now, something that you mentioned, one of the things that become concern of yours is what has been achieved in San Remo itself has not been expressed in other manuals and that. And one of your speculation, or at least something that many of international law scholars has been discussed as well right now, is that the timing in itself, the period when this manual was initially created was like it's a perfect catalyst because there is like this a good sense of globalism, intergovernmental assistance among others. Whereas what we have seen right now, at least in these last 10 years, a gradual development into populism of all countries with more protectionist interests and all that. But also at the same time, you did mention that some instruments out there also having their own success stories. And I do second on that because, like, for example, this recent year, the wildlife treaties on sea wildlife also has been approved. And it was one of the most controversial treaties related to environment, but it does help. It does finally been agreed for. And then one of these discourse that being presented is that the role of representation itself kind of like a strong catalyst, strong pusher for that. So this is what I want to ask you, probably as a point of discussion, right? So in San Remo in itself, even if it's involved many countries, but you describe San Remo as like heavily Western centric as the core theme. But then how San Remo itself fares in terms of global representations? I mean, like recently, right now, I think like international scholars or just scholars in general really interested in the idea of global South, right? Global South ideas and how it is represented. And then we know I think the first thing we learn when we learn about the story of human rights treaties itself, many has been having this rough time because when they are implemented, they have this label as it's not a part of cultural relativisms. Many countries, global South in particular, feel like the ideas of this human rights was not represented. So my question again, sorry, this is a lengthy one. How do you think this representation fair? Does it like matter, especially right now in these terms of when we are tend to be more populism, do we, because we are tend to be more protective, do we have more tendency to like we are willing more to accept more new value unless our ideas be shared? Do you think that's also happening in here? That's all from me. Thank you.
Thank you. That's a great question. And yes, I mean, international law is always fighting against state insularity and against nativism and mistrust, which really has been the hallmark of international relations always, but in particular in the last 5 to 10 years, there has been this real rise of suspicion of other nations, and certainly the suspicion of globalism. And look, with good reason. Globalization has not been the boon everyone was being sold as it was being. There was not, rather than it being a situation where the developing world was suddenly going to be available to access all of these benefits, it became essentially globalization is just a new form of colonialism in terms of the very, very wealthy oppressing the majority of the rest of the world that is not wealthy in that same way, with obviously, you know, heavily racialized overtones. So I think that there is always international law of any stripe, not least of which the law of armed conflict, is always going to be pushing against this really immovable force of suspicion of any attempt to try and promote some kind of bland universality, which international law can sometimes be guilty of. But from my own research, I found that the documents that tended to be received best in practice after San Remo, which again is kind of the exception here, they were the ones that did actually seek the opinion of both the developed world and the developing world, that actually did understand that the world should not be divided just in terms of there's the West and then there's everyone else, because the position of Indonesia on the law of the sea is going to be different to the position of Japan on the law of the sea, or from India on the law of the sea, and they should not be treated as the same simply because of geography. So then I think the documents that tended to do well were the ones that accepted that there was more than just the European view of the world. Because the documents that did very poorly, so the Air and Missile Manual, which was the result of only about 20 or 30 experts primarily drawn from the Western European group, has not had any traction in practice. And one of the really big criticisms of the Tallinn Manual in its first iteration was how much it really didn't take into account issues of sovereignty and from states like India, China, Indonesia, Nigeria, Brazil, that there were really opinions about sovereignty and about cybersecurity that were really not taken into account because nearly all of the experts were American or European. So I think that geographic representation is key to ever getting any of these instruments to actually have any success.
Okay, thank you so much, Prof. Emily. Any response from Mr. Riyad?
Now, I think it's Professor Emily has been perfectly put it. I mean, in our so what I can only say on this matter is that so in the field of discourse of global South in itself, of course, there's always has been the ideas that we sort of like develop this organic concept of international law, not only just in humanitarian law, but in other aspects. I think it just boils down into how to create a representative one. And I think one thing that kind of piqued my interest right now is that if we are slowly moved towards this direction of more a bottom-up ideas of contributing ideas to international law, because I think one thing that at least we scholars sees in the past few decades is that all these instruments, all these manuals, opinion jurists being made, it's tend to be like this high level kind of products. And as we move right now, and UN also acknowledge that we are slowly moving towards something that difficult to control by these high level communities. I mean, to give you an example, so I work in NGOs in Myanmar, and then one of the things that we learn, at least being endorsed by the UN in all different countries of conflict, is related to UNARM's civil protections. It is a concept that not necessarily require the active participation of high-level government, but rather the involvement of society and all those stakeholders in the local society to make those like peaceful structure to avoid humanitarian losses and all that. So this is actually rather new concept, but yeah, I think people start to trying to see how different case studies on that, and then probably it's going to be a elevation ideas to the high degree of discussions. But of course, it's still something that evolved. So yeah, it is something interesting. I mean, regional value is still important, but also maybe for me personally, I think we should start look at more bottom-up ideas of international law. Yeah, we could discover something like that. Thank you again, Professor Amdi.
Oh, thank you for an excellent question and excellent points.
Okay, now we can proceed to the next questions. Please, Jose, you may ask the Professor Emily.
Thank you for the opportunity. Before I start with my question, I would like to introduce myself. I'm Jose Carmario. I currently enrolled as an undergraduate law student in Hasanuddin University. It's really interesting that Professor Emily mentioning about Sanremo. We are in the past few months, we are working on the case when discuss about a naval warfare. So Sanremo manual and other instrument become one of the sources that we are looking for our research. But it comes to my concern that when we want to compare the several binding instrument, let's say in Geneva Convention or Convention on the Law of the Sea, they do talk about process of war, verification and cutting of undersea cable. However, Sanremo manual provide a better understanding, more complex issue concerning this subject, and it's really hard to utilize Sanremo since it the status of this manual as a soft law, making it hard for us to whether we should utilize this one. In your perspective, should Sanremo manual or other soft law such as Stalin manual shall be considered as a teaching of the most highly qualified public, or it shall be considered as a customary international law? Thank you for your.
Yeah, thank you for another excellent question. And obviously, as a pure analysis as a source of law, obviously, Tallinn and the equivalents would be considered the writings of the most qualified publicists. I mean, essentially, they would be considered as in the same category as monographs written by experts or drafts written by the ILC, the International Law Commission. But what is interesting about nearly all of the documents is that they instead profess to be something separate. They do all talk about all of the manuals will have something in their introduction in which they say, this is a statement of lex lata. It's a statement of the law as it exists. It's not, there's been no attempt to try and engage in a progressive development of the law. It's not lex ferenda. So it's interesting that as much as they are as a definitional matter, part of Article 38 1D of the ICJ Charter, a teaching of the most highly qualified publicists, they all tend to position themselves as being a little bit more than that, a bit more special, a bit more unique. And certainly that in the documents that do get used in domestic and international court cases, the Mavi Marmara incident being the most obvious, courts have tended to use them a little bit uncritically as being closer to either restatements of customary international law or almost like treaties, rather than actually treating them like you would a monograph that's been written by an expert or an ILC, ILC draft articles on the protection of the environment in armed conflict. So there is that danger there. And this is why I was so interested in the question of who's involved in this process, how do they come about coming to their conclusions, how well accepted have these been in practice? They don't go through the same kinds of rigorous processes as things like ILC articles. As much as the ILC work is done by a group of rapporteurs, it then undergoes very, very comprehensive engagement with states. States provide drafts, comments on drafts, and they provide their own feedback in a way that just doesn't happen for nearly all of these other instruments. So there really is a concern that states might uncritically, or at least state emanations like domestic courts, might just uncritically accept the ICRC's interpretive guidance on direct participation and hostilities without actually kind of pulling apart, well, what are the methodological concerns or methodological issues that surround this instrument? Is this really a statement of the law, or is this a progressive development? So that's a great question you ask, and yeah, it's they position themselves in this kind of nether realm, which can bring with it its own concerns about lawmaking processes and informal lawmaking processes.
Okay, thank you so much, Prof. Emily, for the answers. Any response from the host?
I do have one response on your answer. So let's say that it shall be considered as a teaching from highly publicist, which is still soft law. It doesn't have any binding enforcement. However, in the development of the customary international, particularly in the area of humanitarian law, can it be possible that certain provision under the San Remo manual have or at least acquire a status of customary law, so it have the binding force? Because let's say in the provision concerning cutting undersea cable, convention on the law of the sea does not prohibit that subject. However, in San Remo, they prohibit cutting in the undersea cable. So this provision, the provision in the San Remo have a better legal protection in certain subject. So is it any possibility that in the future, just this provision in San Remo will acquire the status of customary law?
Yeah, and look, that's exactly what happened with the San Remo manual's provision on specifically protected zones in warfare. So that San Remo took the example of what happened during the Falklands War, of there being basically the idea of a kind of protected zone, introduced that into the law of armed conflict, and that's since essentially been, so that was a progressive development at the time. It was one of the few examples of progressive development in the San Remo manual, which then basically was just accepted as being now standard practice, and so has become customary law. And we're seeing it also in terms of there has been a bit of just generic acceptance of the findings of the ICRC in their customary international humanitarian law study, that it has been just cited without question or without interrogation by bodies like the ICRC. So Sandesh Sivakumaran and Marko Milanovic did a detailed study on the ICRC study in the International Review of the Red Cross. And they said that when it was first released in 2006, it had been subject to heavy criticism about its methodology and about some of its findings, but that in the nearly 20 years since it has been published, it is now essentially uncritically accepted by international and domestic courts as being the statement of customary international law, even though there were some very significant progressive developments in the ICRC customary study. So it is very much the case, and again, this is what gets to the core of why this was so interesting to me, is that you can see how progressive development of the law can happen through these instruments, because states will just look at the document and go, this seems reasonable, let's go with this. And you do it enough times and you have enough of a response, it can then become customary international law, absolutely.
Thank you, Prof. Emily, for the answers. Now we have, is there any questions? Okay, we have one question in the Harapin Tumpa, so please.
Yes.
Okay. Good evening for Prof. Emily and everyone else. First of all, let me say my biggest thank you for this opportunity. It's really an honor for me to be given this opportunity. Earlier, Prof. Emily talked about international humanitarian law, then mentioned about protection of refugees. Something that I want to ask is about how are people in area of armed conflict protected according to international humanitarian law? And then what legal article of law con- can protect them? And what does international humanitarian law promise for their life? Thank you.
Sure. Thank you. Thank you for asking a great question. One of the really big tensions in the law of armed conflict has been that it started out in the 1800s and early 1900s as documents that were designed to essentially enable state violence. That there were documents that said that states are entitled to do certain things in relation to people and property, that they're allowed to kill people, they're allowed to take their property, they're allowed to detain people, all within the framework of it's an armed conflict, and it's a war. In order to meet the objectives of the state in prosecuting that war, they are authorized and allowed and free to do this kind of extensive damage. And the protection of civilians was essentially a secondary concern, really wasn't a primary objective of some of the early documents. The Hague Conventions were really more about trying to protect the participants, about trying to protect people who were taken prisoner as prisoners of war, and to try and protect state property, but not private property, not civilians. But obviously the devastation that took place around the world, really, during the Second World War, because again, it was not just limited to the European theatre of war. Large portions of Asia were subject to terrible, terrible violence. The focus begins to shift in the law, and there starts to be this increasing awareness that civilians in particular are very vulnerable in situations of armed conflict, that these are no longer events that take place on distant battlefields away from civilian populations, that they can engulf urban centers and villages and towns and cities, and that no one can really escape anymore. So the law starts to increase its focus on protecting civilians, to try and spare them as far as possible from the devastation of armed conflict. And parallel to this shifting priority in the law of armed conflict, you start to see this growth in international human rights law, because international human rights law really didn't exist as a field of law prior to the creation of the United Nations. I mean, obviously there were domestic protections for human rights. Most states around the world had protections in terms of things like private law protections for property and protections for things like if you were put on trial or from arbitrary state action, but it's really, as an international concern, something that only develops after the Second World War. And that's where you see the growth of things like law on refugees, law on the protection of children, rules about racial discrimination and things like that. So there's always been a real tension in the law of armed conflict about balancing, or at least the state's interest in protecting its right to the monopoly on violence and the monopoly on legitimate violence, with the need and the desire and the interest in protecting civilians from that exercise of state violence. So there are copious provisions in the Geneva Conventions and the additional protocols with regards to what it's permissible to target. And it works off the fundamental rule that civilians are not to be made the deliberate object of attack in situations of armed conflict. Now, unfortunately, those are rules that sometimes are not followed. We've all been watching what's been taking place in various theatres of war over the past 5 years, not just Ukraine, but also in Syria and in Sudan and in Ethiopia and Yemen. And you really are seeing that while this is meant to be this bulwark of international law, that civilians are to be protected, they are not to be deliberately targeted, we then see obviously those rules being systematically ignored.
Okay, thank you so much, Prof. Emily. We still have one question from Haripin Tumpa, please.
All right. First of all, thank you so much, Professor, for the very insightful material for today's guest lecture. I'd like to raise two questions. First of all, it's a basic questions as most of us in here just got to the introduction of international law. Means that we have to study from the basic one. So as what I got from the lecture, as you speak about the soft law, I would like to ask about the international norms. International norms don't have the first binding of law, nor can be a basis for actions before an international tribunal. Instead, it carries moral weight and expectations to the state. So what happens if a nation fails to observe and to implement this normative commitment? What it will gonna be lead to? And the second one is about the armed conflict that you've just presented. Armed conflict almost always changes the rules that apply to the parties to the conflict, to include the applicable international law. So, for instance, during the peacetime, the international human rights law regime prevails, and under the international human rights law, killing is illegal in most instances unless excused by self-defense or other special circumstances. Much that is legal during an armed conflict is illegal during the times of peace. During an international armed conflict, international human rights law steps aside, and the legal framework of the law of armed conflict prevails. Many killings that would be illegal under the human rights law are legal under the law of armed conflict. Combatants are immunized from prosecutions for killing legitimate targets pursuant to lawful orders given by the chain of command established by their government. So my question is, as the chief of international human rights law and law of armed conflict could be really fast, what can be initiated to declare the chief of both of the subject? Thank you, Prof.
Thank you for those questions. I'll deal with your second question first. What we've seen in the past 15, 20 years, in particular since the US and UK and Australian invasion of Iraq and Afghanistan, is an increasing preparedness by domestic courts to litigate violations of the law of armed conflict in the context of international human rights. So in the UK, there were a number of very important cases where the killing or the torture or the injury that happened to civilians or even to people who were taking direct part in the hostilities was examined in the context of whether it was lawful under international human rights law. So we are seeing an increased preparedness of domestic courts to actually get increasingly involved in saying that armed conflict is not the time where all the rules get ignored, and that international human rights law still has a role to play. I mean, international human rights law only prohibits the arbitrary deprivation of life. It doesn't necessarily prohibit the deprivation of life for non-arbitrary reasons. But increasingly, we are seeing domestic courts being prepared to examine whether or not the deprivation of life in the context of an armed conflict does have that non-arbitrary or arbitrary connection to it. So that is encouraging, because going back to your first question about what is it about non-binding instruments and international law more generally, in terms of how to get compliance with this by states, how to get people to actually follow the rules when it lacks that kind of same normative force that domestic law has. There are always going to be instances where the rules are broken. We will always see states that are prepared to ignore the rules. I mean, America, during its engagements in Iraq and Afghanistan and elsewhere in the world, as well as the UK, as well as in our own country, we're currently grappling with that, with our own war crimes investigations. There will always be people who break the rules. But that doesn't necessarily mean that there should never be an attempt to try and introduce rules. And we do see the benefit of actually having some of those rules, even if it takes longer for a reckoning or a judicial kind of process to follow. So, for example, currently in Australia, we have got a war crimes investigation open regarding the conduct of some Australian service personnel in Afghanistan during the invasion in the 2000s. And it is very clearly going to bring about prosecutions. So they would not exist were it not for Australia's participation in the Rome Statute of the International Criminal Court. So there is some virtue of having rules, even when there is understandable frustration at the lack of enforcement mechanisms, at the seeming lack of compliance. It is a perennial criticism of international law, and there is a decent foundation to it, but it isn't without value.
Okay, thank you so much, Prof. Emily. We still have one question in Zoom. So please, Nurul Habaib, I miss yours.
Good afternoon. Am I audible?
Yes.
Thank you so much. And it is a great pleasure for me to have the opportunity to directly ask to you, Professor Crawford. I'm a fan because I've read some of your books, and yeah, you know, meeting you in Zoom is something I truly treasure.
Thank you. That's lovely.
I would like to ask a question because lately I've been considering that. Well, I might stand corrected, but I heard from your lecture that the reason why Sanremo was drafted is because the failure of the Security Council, and yet, as we've seen that Sanremo was drafted mostly from Western or European countries, then I was considering why not archipelagic states and also small island developing states are involved in this drafting of the Sanremo if the mission of the Sanremo manual is actually for filling the legal gap in the international law. And because the Sanremo manual is actually considered as a highly publishers from the legal scholars, then if, for example, countries who are not involved in the drafting of Sanremo try to draft their own Sanremo manual, would that be also count as a as the same with the existing Sanremo manual?
Yeah, so look, something very similar to that actually happened. So there was an attempt to, this would have been just before COVID. I was hearing about attempts to update the Sanremo manual to actually involve more states in the process, which seemed to then fall apart. And in the interim, a group of experts at the Naval War College in Newport in the United States ended up doing it themselves. And so we now have the 1994 Sanremo manual and we have the 2022 Newport manual. And they do exist side by side. So there is some sense of them supplementing each other and that you would need to read one in order to understand the other. Although the Sanremo manual, the Newport manual does refer to the Sanremo manual and is in some attempts an attempt to update it. So it is something that can be viewed as a whole, but again, part of the appeal of non-binding instruments and these expert manuals and things like that is the idea that anyone can do it, that anyone with an interest in the field can actually get together and decide to draft it for themselves. So there is a great appeal that is offered by these documents. It means that anyone can get into the process of informal international lawmaking. The problem is, of course, that because they are time-consuming and expensive endeavors to be done, if you're trying to do them well, they take a lot of time, they are expensive, they are difficult, and they require the coordination of a number of very complex moving parts, that it really does become something that is remains essentially an elite process, an exclusionary process. And that's what's so disappointing about these things, which is that these are instruments that were, I think, with all good intention, intended to be something that was inclusive, but that in practice, it becomes much harder to do.
Thank you, Prof. Emily. Is there anything, any response from Lulu?
Well, thank you so much for the answer. And I think that, yeah, I was just considering that I believe that Sanremo manual would be very different if countries like Indonesia are involved in that drafting process, because like
Yes.
certain states might not have the same characteristic with Indonesian, yet it would be I don't know, let's just say quite different, especially conflicts in the sea when it comes into areas like Indonesia. Thank you so much for the insights.
That's all right. Thank you for an excellent question.
I think that's pretty much for the question and answer sessions. Before we end this lecture, is there anything to add, Prof. Emily?
Look, I just wanted to, and I should have said this at the beginning, but I just kind of launched in. I just wanted to say it's been an absolute privilege and honor to be able to speak to you all tonight. It's been wonderful. As much as Zoom can be quite impersonal, it does give you the option of being able to actually talk to a wide variety of people. And so I've been absolutely thrilled, and I must thank Alif, my student from earlier this year, who reached out and asked me to participate, and also to the faculty more generally. It's been an absolute privilege.
Okay, thank you, Prof. Emily. We from the Faculty of Law will present the certificate for the Prof. Emily as the appreciations for today's lectures. Oh, okay. Prof, before we proceed to the certificate, please, Prof. Pak Laude M. Sharif.
Echo, thank you very much. I hope I'm audible because I'm in the car actually. But on behalf of the Department of International Law of the faculty, I just want to accompany the Deputy Dean to thank you for your insight. And as an alumni of Sydney University Law School, I'm happy that actually our faculty are reaching out to you. And again, I hope we can actually meet in person in the future. And again, thank you very much. And my students are very, very happy with your lectures. Thank you, Prof.
That's lovely. Thank you.
Thank you.
Now we proceed that our Faculty of Law will present the certificate for Prof. Emily as the appreciation for today's lectures.
Thank you. That's lovely.
Thank you so much, Prof. Emily, and thank you so much for Pak Alif, who gave us an assistance for today's lectures. Now I think that's pretty much for today's lectures. Thank you, Prof. Emily, and thank you for all the participants. Now we hand over to the Master of Ceremony.
All right, finally, we've come to the last agenda, which is closing. Let's close today's agenda by reciting Hamdalah. Alhamdulillah. And we humbly please all of the participants to come forward for documentation's purposes. We also invite Pamaskun to come forward to documentation purposes. Okay. Oh. All right. For the participants in Zoom, you can turn on your camera, please. Okay. Count on 3, 2, 1. All right. Thank you so much, Prof, once again for the very insightful presentations for today. We would like to thank all of the participants who have attended this afternoon. We apologize if there are any intentional or unintentional wrongdoings during this event. And we sincerely hope that any lessons we got today can be useful for the future. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Professor Crawford.
Thank you.
Thank you, Prof. Emily.
Thank you. I hope to see you in Sydney all sometime. Please feel free to reach out if you have any more questions.
Sure.
Thank you.
Sir, I believe you are muted.
Sorry, thank you. Lid, thank you ya Lid ya udah bantuin fakultas Ya Pak, terima kasih. Insya Allah moga-moga saya untuk undang dosen-dosen lainnya lancar. Saya sudah kontak beberapa dosen, Prof. Penny sama Prof. Chester Goron sudah saya kontak, tinggal menunggu balasan mereka. Semoga mereka berkenan karena kuliah hukum juga.
Iya, Lip dan yang insya Allah nanti kita WA-an lagi ya untuk Profesor Beverly.
Ya. Kemarin saya juga berbicara sama Profesor Simon Bat, dosen pakar Indonesia di sini dan berkenan juga. Pokoknya nanti kita bicarakan lagi. Prof.
Oke,
Terima kasih.
oke, thank you ya.
Oke.